I want to be clear. I accept the court's decision and take its findings very seriously. Minister Lametti and I are committed to implementing the court's recommendations. I believe that in the case at hand, CSIS carried out its mandate in good faith and acted at all times in the public interest. The potentially illegal activities involved in this case are in fact common intelligence collection activities used around the world by national security and law enforcement agencies to investigate terrorism and to keep their citizens safe. At no time was the safety of Canadians placed at risk, nor, in my opinion, were our rights and freedoms threatened.
Canada's spy agency, also known as CSIS, has once again come under intense scrutiny in the courts. In a ruling released today, a federal judge found the intelligence service used illegal means to obtain information and then used that information to get warrants in their counter-terrorism investigations. The judge now wants a review of CSIS, calling this evidence of, quote, a cavalier approach to the rule of law. CSIS director David Vigneault said in a statement today that he takes the court's findings very seriously and that he's committed to ensuring that the spy agency, quote, fully understands our obligations to the court. In just the last hour, Minister of Justice David Lametti responded to the ruling. Have a listen.
We are appealing this decision on a narrow but important point of law, which, if allowed to stand, would create a precedent for future cases. But let me be crystal clear. We agree with the court's finding that serious institutional failures led to a breach in the government's obligation to the court. This appeal does not and should not take away from the important task at hand of remedying these failures and fully meeting our obligations to Canadians.
Let's dig into exactly what the court says CSIS did wrong and whether it can be fixed. Jessica Davis is a former strategic analyst with CSIS. She's now president of Insight Threat Intelligence. And Leah West is a former national security lawyer in the Department of Justice. She's now a lecturer of national security and intelligence at Carleton University's Norman Paterson School of International Affairs. Both are very familiar faces to this program, and they join us from Ottawa. Hey, guys, great to see you.
Nice to see you.
Leah, I'm going to start with you because I think we should start off by trying to understand the conclusion that the judge reached, and especially when it comes to that clip we pulled out right at the top of the introduction, a cavalier institutional approach to the duty of candor and regrettably the rule of law. In layman's terms, what does that mean that CSIS did wrong?
So the duty of candor refers to the obligation that counsel representing CSIS, the Department of Justice counsel, and CSIS and officials have when coming to the court and asking the court to authorize certain warrant powers. So the ability for CSIS to do the intrusive activities it needs. Because it comes to the court and there's no opposite party, there's nobody else in the room to contest what CSIS is saying or test their evidence, CSIS needs to be really, really candid with the court about the strengths and weaknesses of its case, the reliability, the credibility of its information, the evidence, and the sources it's relying on, so that the court can properly assess whether the statutory obligations are met for CSIS to get a warrant. And here, when the court says that there's a failure in the duty of candor, it means that CSIS didn't tell the court everything the court needed in order to make its assessment about whether or not CSIS should get the powers it was hoping to get in its investigation of Islamic extremism and foreign fighters.
And the powers, Jessica, that CSIS was hoping to get, you had a tweet, I went through your tweets today because they were very helpful, but one of the, provision of funds to terrorists, provision of funds to sources who provided funds to terrorists. Like, what exactly was CSIS trying to do here?
There's a really handy chart at the end of this decision, and it really outlines all of the different ways that CSIS contravened the Criminal Code of Canada. And that was really under the terrorist financing provisions. So in most of the instances that are outlined in this decision, CSIS provided funds to a terrorist or somebody known to be engaging in terrorist activity or facilitating terrorist activity. That's really serious, actually. When you provide funds to a terrorist organization or individual, that money isn't necessarily doing what you think it is doing. So there's a reason that this is illegal. And we also have international obligations to not fund terrorism. So that's really the crux of what CSIS was doing here. They were also providing source payments, and that source payment, the sources were providing some of those funds to suspected terrorists as well. And when the CSIS director talks about this being the bread and butter of intelligence agency activities, I would agree that source payments definitely are. But I think there's a bit of a difference when you start providing funds to terrorist actors directly.
Yeah, I want to just quickly follow up with you on that because I want to quote exactly what Mr. Vigneault said. I hope I'm pronouncing that correctly. This decision, the types of activities in question in this decision are representative, and the quote is, of routine bread and butter practices used by allied intelligence agencies around the world. It's kind of, everyone's doing it. Everyone in this position is doing it. Is that enough to say, Jess, that it's okay?
I think certainly paying sources is a very important aspect of the intelligence business. When we start getting into providing funds to people who are potentially going to engage in terrorist activity, that's where I start to hesitate a little bit. And this is exactly the kind of thing that the National Security Intelligence Review Agency and the Committee of Parliamentarians should look at in their review of this activity. How much was provided? How did CSIS ensure the end use of funds? And what was the ultimate use of those funds? And was it strictly necessary to achieve their objectives?
I'm a little bit confused, Leah, and I hope you can help me understand on what exactly the court was saying. Is it that CSIS shouldn't have done that stuff, or the way in which it went about doing it wasn't the right way? Like you should have met certain conditions. You should have had different legal advice to make sure that what you were doing was legally sound.
Kind of a bit of both.
Okay.
So realistically, CSIS was given legal opinions, or CERC, its former review body, raised the issue that engaging in this kind of activity was criminal, and that CSIS wasn't protected by what's called Crown immunity, which would alleviate the unlawfulness of what CSIS was doing because it works for the Crown. It said, you're not protected by Crown immunity. So when you engage in these activities that violate the criminal code, your officers are likely committing criminal offenses. CSIS had that information, had that legal advice. It was never fully solidified as a strong, firm legal opinion, apparently until 2019, despite the fact that CSIS had received previous opinions in 2017 and actually stopped doing this type of work because of that opinion. But the issue is CSIS knew what they were doing was unlawful in terms of criminal offenses. They proceeded to do it anyway. And then when they got information from that, they put it into the warrant applications without telling the court where they got it from. And that has an impact on how the court would assess the reliability and the credibility of some of that information.
That's super helpful. Jessica, what does that mean for, and Leah pointed out that some of these practices have already stopped, but what does this mean for the way in which CSIS moves forward? Like, what do you expect? How do you expect this is internalized there?
Yeah, so in terms of the way CSIS moves forward, I think, a lot of the activities that are outlined in this case will likely continue, probably subject to additional scrutiny and hopefully, again, additional advice from the courts and also input from National Security Intelligence Review Agency. So I think that will likely continue in the short term, possibly even the long term. These are very important operational activities. So while I raised the severity of them earlier, a lot of them do help you gain access to terrorist networks. You can't just walk up to somebody you think is engaging in terrorist activity and say, look, I really need you to give me some information. You're going to have to pay for it. You're going to have to prove your bona fide somehow. You're going to have to gain access. So this is a really important way to do that.
So Leah, if other agencies are in fact conducting themselves in this way and using these practices, as the head of CSIS says, in other jurisdictions, is the bar for proving, I guess, that they need to be used similar, or is it different depending on the jurisdiction?
So the issue really isn't about other countries do it and so should we. Yes, CSIS now has the authority to do this lawfully, and it's justified under the CSIS Act. So part of what Bill C-59 did was it cleared up this issue about whether or not CSIS could or could not engage in this kind of practice.
And sorry, let me just interrupt you for a second to tell our viewers that is the big national security piece of legislation the Liberals brought in their last mandate, right? It actually ended up passing and coming into force right at the end.
But the problem is that legislation was introduced in June of 2017. Right? And for years, while CSIS was telling Canadians, we are at high legal risk. We need these powers because our agents, our officers are doing things that might bring the administration of justice into disrepute, might cause us to question the rule of law because they don't have the legal authority to be breaking the law. They were still doing it. And that's a big problem when you're talking about the rule of law and national security oversight, is that we had an agency that was given legal advice, was telling Canadians that they needed the new legal authorities to do things, because if they didn't, their officials were at risk of criminal liability, and they still did it.
Gotcha. Okay, well, I have to leave it there because Dr. Dina Hinshaw has just stepped up to the microphone, but you've both helped me and I hope our viewers immensely understand the significance of this decision. Thank you very much for your time tonight. Thanks to Jessica Davis. She's a former strategic analyst with CSIS, and Leah West, a former national security lawyer in the Department of Justice. Hi, I'm Vashi Capellos, host of Power in Politics. See more of our show by subscribing to the CBC News channel or click the link for another video.